delighted that you could make it tonight. I'll just say a few words about our speaker. We're really fortunate in having the Honourable Wayne Martin, who's the current Chief Justice of Western Australia. He was admitted into practice in 1977, and in 1993 he was appointed as Queen's Counsel. At different times he served as Chairman of the Law Reform Commission of Western Australia. And can I just say that that chairmanship, I think, was inspiring in relation to all law reform bodies in Australia. And he's also served on the Administrative Review Council and as President of the Law Society of WA and the West Australian Bar Association. In 2006, he became the 13th Chief Justice of the Supreme Court of Western Australia. In 2012, the Chief Justice was recognised nationally when he was appointed a Companion of the General Division of the Order of Australia. The Chief Justice currently holds many positions as Chairman or Patron and is also the Lieutenant Governor of Western Australia. The Ninian lecture series, which we're hearing from tonight, was established in 1993 to mark the arrival of the first group of law students at our law school. It's delivered by an eminent lawyer each academic year, and the first lecture was delivered by Sir Ninian Stephen, a Justice of the High Court who passed last year. Without further ado, I would like to welcome our Chief Justice from Western Australia, Wayne Martin. Thank you, Wayne.
Thank you very much, Tanya. I'm greatly honoured to have been invited to give this year's lecture in honour of Sir Ninian Stephen. Delivery of this lecture not only places me in the august company of the many celebrated speakers who have preceded me, but also gives me the opportunity to pay tribute to a great Australian. I never had the opportunity to appear before Sir Ninian in his judicial capacity, but my wife and I had the great fortune to be seated at the same table as Sir Ninian and Lady Valerie at a dinner held in the foyer of the High Court in Canberra, quite some time after he had completed his term as Governor-General. Although both were by then of advancing years, their contribution to discussion at our table revealed great insight into a wide range of domestic and international affairs. And of course, this evening's address has a particular poignancy, as is the first to be delivered since Sir Ninian's passing in October last year. Sir Ninian was, of course, a lawyer by training and became a distinguished jurist. However, the breadth of his extraordinary career and his engagement with many areas of endeavour beyond the law and the courts provides a convenient metaphor for my address this evening, as I'll be discussing the ways in which the courts and the broader justice system can and should engage with broader societal community values in order to improve the health and welfare of our community. Sir Ninian was recognised as a leader of the Victorian Bar at the time of his appointment to the Supreme Court of Victoria in 1970, which shortly preceded his appointment to the High Court of Australia in 1972 at the relatively young age of 48. After 10 years of service on the High Court, he was appointed to the office of Governor-General in 1982, again at the relatively young age of 58. This meant that following his retirement in 1989, after 7 years of service as Governor-General, he was still only 66. His remarkable energy and vitality provided him with the opportunity for distinguished service in a variety of fields, after serving as the nominal head of government in Australia. Sir Ninian became Australia's first ambassador for the environment and worked energetically for the imposition of a ban on mining in Antarctica. He served as chairman of the second strand of peace talks in Northern Ireland and as an ad hoc judge of the International Court of Justice. He also served as a founding member of the International Criminal Tribunal for the former Yugoslavia and on the tribunal set up to investigate genocide in Rwanda. He served as a mediator between the government and the opposition in Bangladesh and as leader of the United Nations delegations to Cambodia and to Burma, as it then was. Sir Ninian's successful engagement in a wide variety of fields beyond the law reminds us that lawyers and judges are, after all, human and have the capacity to engage with others in ways that are not limited to the mechanical application of the law. Sir Ninian's humanity and his fundamental decency were conspicuous in all aspects of his work and career and provide a shining example of the contribution which lawyers can make to our society when we look beyond the routine application of the law and engage with broader societal values. As I'll shortly be addressing the relevance of Aboriginal customary law to my topic this evening, it's pertinent to note that as Governor-General, Sir Ninian officiated at the ceremony marking the return of Uluru to the traditional owners in 1985. as his biographer observed, and I quote, "This was the most symbolically significant transfer of ownership to Australia's Aboriginal peoples during Stephen's tenure as Governor-General, and his speech was an effort to balance specifically Aboriginal rights, morally based in natural law, in the light of historical catastrophe and dispossession, with the concept of national unity." As my friend Frank Brennan noted in his 2006 Stephen lecture, following that important ceremony, Sir Ninian and Lady Valerie made frequent visits to remote Aboriginal and Islander communities, often staying in quarters which had not previously hosted vice-regal guests. I'd like to thank Beck Bell for her generous welcome to country, and I'd like now to pay tribute to and respectfully acknowledge the traditional custodians of the land on which we meet, the Awabakal and Worimi peoples. I pay my respects to their elders past, present and emerging, and acknowledge their continuing stewardship of these lands. Although I'll be saying more about the concepts of restorative justice and restorative practices later, what lies at the heart of these concepts is collective participation by all those with an interest in a particular dispute for the purpose of ascertaining how to deal with its consequences. These notions can be contrasted with retributive justice, which is concerned with the authoritarian imposition of punishment by a third party, usually the state, acting through representatives who have no particular stake or interest in the controversy. The earliest structures or mechanisms for the resolution of disputes in what became England and Wales involved significant degrees of community participation, including participation by all those with an interest in the events which gave rise to the dispute or grievance. But following the Norman conquest in 1066, these mechanisms and structures were increasingly adapted to serve as means for the imposition of the authority of the monarch through the agency of the travelling justice appointed by the king. The focus shifted away from the provision of redress to the aggrieved and toward the imposition of punishment. The punishment imposed was determined by the court, acting with the authority of the Crown, or, after the establishment of parliamentary sovereignty, the state. Greater emphasis came to be placed upon the interests of the state in the maintenance of law and order, with decreasing interest and attention being paid to the interests of victims, or in the case of homicide, the secondary victims of the offence. We shouldn't overlook the fact that the development of this authoritarian and fundamentally punitive model of justice played a major part in the colonisation of Australia. After the American Revolution, the English authorities had nowhere to send the many prisoners who were temporarily detained in rotting hulks on the Thames estuary. In order to avoid the capital cost of building new prisons and the recurrent costs of feeding and clothing the prisoners within them, it was decided to transport the convicts to a new colony to be founded using their indentured labour. That colony was, of course, the colony of New South Wales, which initially embraced the entire east coast of the continent, Tasmania and New Zealand. Although the Swan River colony, which became Western Australia, was not established using convict labour, the advantages to be derived from utilising essentially free labour to clear land and establish infrastructure were soon realised, and the Imperial government was requested to dispatch convicts to the fledgling colony, which it did. The prison in Fremantle, which those convicts built in the 1850s, was still in use when I commenced my legal career, although happily it now serves as a somewhat gruesome tourist facility, which, like other similar facilities, such as the former Maitland Jail, provide tangible reminders of the punitive objectives of colonisation. By contrast, the Indigenous peoples who were dispossessed by the colonists had a very different approach to the resolution of disputes and conflicts. Before referring to those mechanisms, I need to sound a note of caution against generalisation in this area. Although estimates vary and none can be regarded as completely accurate, it's thought that at the time of colonisation there were more than 500 different tribal groups living in the area which we call Australia. Although there were some similarities in the mechanisms for the resolution of disputes and conflict within those tribal groups, there are also differences. So the descriptions which follow shouldn't be regarded as universally applicable to all tribal groups at the time of colonisation. According to Berent and Kelly, conflict within Aboriginal society prior to colonisation often arose in circumstances which included failure to observe sacred law or ceremonies, such as failing to get permission to use certain tools or failure to get permission to enter sacred places, breach of kin obligations, such as not giving portions of hunted food to relatives as the law required, improper use of sorcery, breach of marriage arrangements such as elopement, breach of marital obligations such as with adultery or withholding sex, and unlawful acts against a person, such as injuring or neglecting children. Councils of Elders would not only decide cases brought to them, but would also intervene proactively in disputes if they weren't resolved by the participants. Brent and Kelly have referred to the roles played by the Councils of Elders in the resolution of conflict, together with a variety of mechanisms used by different tribal groups. For example, they've described the mechanisms utilised by two clans of the Lower Murray River people when attempting to settle a dispute. The members of the disputing clans sat facing each other, while members of other clans were arranged around their negotiators or spokespeople for the disputing clans. The Council of Elders began with a general discussion, followed by statements by the accusers, the defendants and their clans, and the statements by those who'd witnessed the events giving rise to the dispute. Similar processes were utilised by the Wiradjuri people of central New South Wales, by people in Arnhem Land and in the Kimberleys. As will be seen, these processes of collective participation, involving all those with an interest in the dispute, which aim to identify the way in which the dispute could be resolved and the community could move forward harmoniously, have many similarities to what we now describe as restorative justice. The same can be said of the practice described by Berent and Kelly of airing a dispute with an open display of anger, in which the aggrieved person yelled about the offender and the wrong done to him or her. The purpose of airing the dispute openly was to bring public pressure upon the wrongdoer to make redress to the person aggrieved. Berent and Kelly point out that uncontrolled retaliation was discouraged, and disputants were encouraged to spend time getting their emotions under control before they faced the person with whom they were in dispute. Women were especially important in this process, using their influence to ensure that unauthorised violence did not occur. Berent and Kelly also point out that the dynamics of a small, interdependent community made social pressure an extremely effective sanction to settle a dispute or enforce a punishment, and the disputes were often settled by restitution, such as by offering gifts to the offended person or by performing ceremonies to show respect or to bring about an increase in natural resources to the country of the offended person. Sanctions which could be imposed through these processes included exile and spearing. Although superficially punitive in nature, these sanctions had restorative elements as they were imposed by the offended person or community. In the case of spearing, the offender would be placed in opposition to the aggrieved person, or in some cases the clan of the aggrieved person, who would then throw spears and boomerangs at the offender, and exile would be enforced by the offended community. As Berent and Kelly observed, dispute resolution in pre-invasion Aboriginal culture reflected the values of the people. These were vastly different to the values of the British legal system, which was to evolve into the Australian legal system. In its report on Aboriginal customary laws, the Law Reform Commission of Western Australia summarised the differences between traditional Aboriginal dispute resolution methods and the Australian criminal justice system in the following terms. They observed that Aboriginal dispute resolution methods involve the family and communities, while in Western legal systems, strangers determine disputes and impose punishments. The disputants are directly involved in customary law processes, which can be contrasted to the use of advocates and third parties under the Australian legal system. Aboriginal customary law decision-making is collective and by consensus, rather than the hierarchical nature of decision-making found under Australian law. The restorative character of traditional Aboriginal dispute mechanisms is evident in these comparisons. It's also evident in observations made by Ruby Langford-Genebi to the effect that, and I quote, "The process of the law was one of political negotiation that involved everyone in the community. Settling disputes under Aboriginal law was part of the purpose of the great gatherings of Aboriginal people. Aboriginal customary law is heavily influenced by the need to avenge the victim." So, over the period of at least 60,000 years prior to colonisation, the original inhabitants developed systems for the resolution of dispute and conflict which have many of the characteristics which we today associate with restorative justice. Over the centuries which followed colonisation, those mechanisms and practices were overborne by the authoritarian and fundamentally punitive processes which the colonists brought with them from Europe. Happily, the last few decades have shown increasing awareness of the deficiencies in an exclusively punitive approach to breaches of the law, accompanied by a greater awareness of the advantages of a more restorative approach of the kind practiced over many millennia by the original inhabitants of the lands we now occupy. As I've noted, the colonists from England and Wales brought with them a fundamentally punitive approach to criminal justice which has a long and rich cultural tradition in the place from which they came. Indeed, without that tradition, they may not have come at all. those cultural traditions seem to have given rise to contemporary community views about the utility of punishment, which are based more upon intuition than upon reasoned analysis or evidence. I entertain great doubt as to whether contemporary community values relating to criminal justice can be accurately gauged from statements made by callers to talkback radio, or bloggers, or correspondents to newspapers, or even by editorial pieces in printed media. The unreliability of sources such as these as a guide to contemporary community values is a topic for another day. It's sufficient for my purposes to observe that, whether they are reliable or not, these sources motivate legislators all around Australia to enact increasingly punitive laws in response to what they perceive to be community expectations. In most, if not all, Australian jurisdictions, including my own, general elections are preceded by a law and order auction in which political contestants endeavour to outbid each other in their punitive approach to crime. Participants in political debates with respect to these issues rely upon the assumption that a majority of electors firmly believe that increasing levels of punishment generally and reducing the discretion of the courts by imposing mandatory minimum sentences will make the community safer. That assumption is never questioned. Tragically missing from any political debate with respect to these issues is any reference to evidence or any form of analysis aimed at assessing whether the community might be made safer by other or more nuanced and varied responses to criminal behaviour. Any reasoned analysis of the policies which are likely to reduce crime and make our community safer would probably start with the identification of what criminologists call criminogenic factors, that is, the factors which contribute to or are associated with, either singly or in combination, criminal behaviour. That process of reasoning embodies the fairly simple proposition that if you want to effectively stop or reduce some phenomenon from occurring, it's useful to know what's causing it to occur in the first place. Policies which reduce the incidence of these causes can be expected to reduce the incidence of the crime which these causes produce or with which they're associated. It's unnecessary to draw upon detailed social research to identify the factors which are associated with the commission of crime in Australia. These factors are well known. They'll be obvious to anybody who has, like me, spent a considerable amount of time in criminal courts. They include mental health issues, including mental illness and cognitive disability, substance abuse, both legal in the form of alcohol and illegal, homelessness, exposure to physical abuse, domestic violence or sexual abuse as a child, placement in out-of-home care as a child, fetal alcohol spectrum disorder and Aboriginality. These factors, either singly or more commonly in combination, contribute to or are associated with the vast majority of crime committed in Australia. A purely punitive response does nothing whatever to address or mitigate any of these factors. Although Australia's prisons are by far the biggest providers of institutional mental health care in our country, they couldn't be described as therapeutic environments conducive to the restoration of mental health. Nor are they places conducive to training those who suffer from cognitive disability to identify and avoid the risks of criminal behaviour associated with their condition. Nor has imprisonment of itself been shown to be particularly effective in reducing substance abuse or dependence, especially given the relatively free availability of illicit substances in Australia's prisons. The regular law and order auctions which I've described and the increasingly punitive policies which have emerged have caused Australia's prison population to grow at a much faster rate than reported crime. For example, over the last 2 years in Western Australia, the prison population has grown 10 times faster than the general population. Most Australian prisons are now chronically overcrowded. The attention and resources of prison authorities are understandably focused upon the constant struggle to satisfy the ever-increasing demand for accommodation, for food and for clothing. The capacity of those authorities to provide treatment for mental illness, behavioural therapy to those with cognitive disability, treatment to those dependent on substances, programs relating to substance misuse, anger management or violence aversion, even basic numeracy or literacy training or the most mundane forms of occupational training are all severely compromised by the overcrowded environment in our prisons and the consequent focus upon containment. To put it bluntly, for many Australian prisoners, all that happens while they're in prison is they get a little older, spend time with other offenders and perhaps improve their criminal skills before being released back into the community. This admittedly superficial analysis leaves me pondering aloud as to why Australia's legislators, and inferentially at least the communities they represent, persist with increasingly punitive policies and laws which have no impact whatever upon reducing or mitigating the factors which we know are associated with criminal behaviour. The same basic point can be made in a number of different ways. For example, sentencing laws and practices differ widely as between similar jurisdictions in Australia and overseas. Criminologists assess imprisonment rates by reference to the number of prisoners per 100,000 in the general population. Imprisonment rates assessed in this way vary significantly, very widely indeed, as between the different Australian jurisdictions, even after allowance is made for the proportion of Aboriginal people within those jurisdictions. And that is, of course, the factor which has the single most significant impact upon imprisonment rates in any jurisdiction. Although those rates fluctuate from time to time, the imprisonment rate in Victoria has traditionally been much lower than the corresponding rates in New South Wales and Western Australia. If, as appears to be commonly assumed, increased punishment reduces crimes and makes communities safer, one would expect jurisdictions with tougher sentencing laws and practices and higher imprisonment rates to have lower levels of reported crime. But the evidence doesn't suggest any correlation between general levels of punishment within a community and general levels of reported crime. That proposition can perhaps be most starkly illustrated by comparisons with the United States of America, where imprisonment rates are many times those which prevail in Australia, and which are the highest in the world by a large margin. The land of the free and the home of the brave locks up its population at a rate much greater than any other country on the planet. Nobody would seriously suggest that those levels of punishment have made the United States the safest place in the world when it comes to criminal conduct. Another way of illustrating the same point is by focusing upon the notion of deterrence, which underpins the assumption that increasing punishment will reduce crime. Let us apply that proposition to three categories of prospective offender. The first category being offenders who believe they will be apprehended, the second category being offenders who believe they will not be apprehended, and the third category being offenders who believe they might be apprehended. Let's now apply a changed law to the offence which each category of offender is contemplating, which has the consequence that a minimum penalty of imprisonment for 2 years will be increased to a minimum penalty of imprisonment for 6 years. Let's also assume that these prospective offenders are both aware of the change in penalty and apply that awareness to a rational evaluation of their prospective offence, an assumption which is a necessary prerequisite to the validity of deterrence theory, but which is entirely contrary to my experience in dealing with those who commit crimes. But on the assumptions which are required to give any validity to a deterrence theory, the increase in penalty will have no impact upon the category of offenders who believe they will be caught, because a penalty of 2 years imprisonment will be sufficient to discourage them. Equally, it will have no impact upon the category of offenders who believe they're not going to be caught, because they don't believe they're going to be penalised at all. So the increase in penalty will only have an impact upon the category of offenders who believe they might get caught, and to evaluate their prospective criminal conduct by undertaking a sophisticated risk-benefit analysis, bring into account an evaluation of the chances of being caught, the benefit likely to be derived from their crime, and the penalty likely to be imposed. Now, anybody who thinks that the category of offenders undertaking risk-benefit analysis of this degree of sophistication represent a significant component of those who commit criminal offences should spend a little time in a criminal court sometime. Put more bluntly, punitive policies led to the foundation of the country, which we know as Australia, and have dominated public policy since colonisation. Since colonisation, enthusiasm for punitive responses to levels of crime have waxed and waned. But there doesn't seem to be any correlation between punitivism and the level of crime. If punishment was in itself effective in reducing crime and improving community safety, the very severe penalties which have been imposed for drug trafficking and child sex abuse for decades now would have reduced the incidence of crimes of that kind. Tragically, however, crimes of that kind continue to proliferate, apparently irrespective of the levels of penalty imposed. So far, I've been assessing punitive justice policy solely by reference to the policy objective of reducing crime and making the community safer. Of course, the criminal justice system must serve objectives broader than that. Those objectives include giving expression to the community desire for the imposition of punishment for its own sake, an eye for an eye and a tooth for tooth, and so on. And the importance of the retributive objective of punishment should not be overlooked or diminished. But under current systems of criminal justice in Australia, retribution or punishment is imposed on behalf of the state and to reflect the interests of the community as a whole, consistently with the system we inherited from our colonial forebears. Although recent decades have seen legislative amendments in most, if not all, Australian jurisdictions requiring courts to take into account the interests of victims and to provide victims with the opportunity to advise the court of the consequences of the offence, conceptually punishment is still imposed in the interests of the community as a whole, rather than in the interests of a victim or victims, or as a manner of redress to a victim or victims. As a consequence, many victims continue to feel disempowered by the justice system, continue to feel deprived of any opportunity for meaningful engagement with that system, and that's where restorative justice comes in. So what is restorative justice? Any attempt to define or explain restorative justice must start with the admission that the concept is nebulous and imprecise. One way of explaining the notion is by reference to the principles which underpin it. They include a shift away from the traditional view that prison is an effective deterrent from future offending, consistently with the proposition I've been developing earlier. The Australian Institute of Criminology suggests that restorative justice can be differentiated from the conventional criminal justice system in the following respects. Rather than crime being seen as a violation of law which is committed against the state, it's perceived as a conflict between individuals which has resulted in harm to victims and communities. Where the traditional approach seeks to determine guilt and impose punishment, restorative justice is more concerned with repairing the harm caused by offending and restoring relationships. Restorative justice processes provide an opportunity for active participation by victims, offenders and their communities, which is a departure from the passive roles offered to them by the traditional criminal justice system. It seems that the most commonly accepted definition is that proffered by Marshall in 1996. Namely, restorative justice is a process whereby all parties with a stake in a particular offence come together to resolve collectively how to deal with the aftermath of the offence and its implications for the future. The imprecision of the notion of restorative justice derives in part from the wide range of practices which can be embraced within such a broad concept. Those practices include diversion from the criminal justice system, both at the pre-court or court stages, meetings between victims and offenders, circle sentencing practices, neighbourhood justice centres, and so on. Central to all of these processes, however, are notions of reparation and restoration. Those notions are embodied in a more recent definition of restorative justice proffered by Zia. He said, restorative justice is a process to involve, to the extent possible, those who have a stake in a specific offence and to collectively identify and address harms, needs and obligations in order to heal and put things as right as possible. The Australian Dispute Resolution Advisory Council, which I'll call ADRAC, has described the goals of restorative justice as being to divert offenders, particularly juvenile offenders, away from court proceedings, to allow for community involvement, to provide an active role for victims in the criminal justice process, to support victims of crime and assist their recovery, to increase confidence in the sentencing process amongst participants, to encourage healing, to allow the offender to make amends, to empower the offender, the victim and communities, and to address the causes of offending. Now, Professor John Braithwaite is an Australian scholar who's a leading international figure in this field and who, as a keynote speaker at the conference that's going to be held over the next 2 days in Newcastle, has drawn attention to the connections between restorative justice and democracy and accountability and responsibility. He describes restorative justice as an accountability innovation, which is re-democratising criminal law. Accountability is enhanced by obliging offenders to interact with their victims, by providing victims with the opportunity to seek reparation from offenders. Democracy is enhanced by providing everybody who has an interest in the events which constituted the offence with the opportunity to participate in the process which determines what the consequences of the offending behaviour will be. Braithwaite also suggests that restorative justice can be viewed in a much broader context in which similar processes and practices can be used in many other fields of human activity. As he puts it, injustice in the way states fight wars can be confronted by restorative justice strategies such as truth and reconciliation commissions. Injustice in the way children are treated in schools can be confronted by restorative anti-bullying programs. Injustice in the way large private bureaucracies treat us as employees or consumers can be confronted in restorative justice circles or conferences. Unjust treatment by public bureaucracies such as tax officers is equally a site of restorative justice research and development. Braithwaite describes restorative justice as, and I quote, a horizontal process of democratic deliberation that's integrated into external processes of accountability to courts and the rule of law. This integration of direct democracy and the rule of a representative democracy's laws is an opportunity to enrich thinking about the relationship between responsibility and accountability in a democracy. Responsibility is conceived here as an obligation to do some right thing. Accountability is being answerable to give a public account of something. The restorative justice ideal of responsibility is active responsibility as a virtue, the virtue of taking responsibility, as opposed to the passive responsibility we are held to. And the restorative justice method for engendering active responsibility is to widen circles of accountability. Now, Braithwaite has other quotes along the same lines, which in the interests of time I'm going to skip over, but they will be in the paper that will be published in a variety of places, including the website of the Supreme Court. Moving on then to restorative practices. Restorative justice is to be distinguished from restorative practices, although clearly the two are closely related. Restorative practices go beyond the justice system, consistently with Braithwaite's views, and introduce the concepts which underpin restorative justice in a broader field of community activities, including education, social services and workplaces. Mediations, conferences, relationship building exercises and other mechanisms for improved communication between all those people with an interest in a particular issue or dispute can be applied outside the justice system, in schools, in workplaces, in government departments, indeed anywhere. It's the augmentation of restorative justice with restorative practices that can result in a city or a community being regarded as a restorative city or community, which is a concept to which I'll return. Restorative justice should also be distinguished from the bundle of concepts sometimes collected under the heading therapeutic jurisprudence. And although the notions are related and each can be regarded as a species within the genus of non-adversarial justice, the notion of therapeutic jurisprudence is essentially the notion of focusing upon and attempting to address the causes of crime rather than its consequences. That notion has undergone changes in terminology over the years, including its replacement by terms such as problem solving and solution-focused judging. The main differences between notions of that kind and restorative justice is that solution-focused courts primarily address the needs and interests of the offender, whereas restorative justice processes continue to give significant weight to the needs and interests of victims. Restorative justice has a relatively recent history in post-colonial Australia, or indeed anywhere. Another leading writer in the field, Heather Strang, places its origins in the year 1989 with the introduction in New Zealand of the Children, Young Persons and Their Families Act and the publication of Braithwaite's seminal work, Crime, Shame and Reintegration. The New Zealand legislation led to the establishment of the Family Group Conference Program in the area of juvenile crime, and this became the model for a program set up in Wagga, New South Wales in 1991 following a visit by an Australian police officer to New Zealand. Connections were drawn between what was occurring in New Zealand and the principles enunciated by Braithwaite, which in turn resulted in the introduction of a conferencing program in the Australian Capital Territory, which in turn led to empirical research on the outcomes of that program, which was conducted over a very lengthy period. Members of the research team following events in the ACT were successful in obtaining funding to undertake research in the UK in respect of restorative justice programs developed in that jurisdiction, and that is how the movement grew and flourished. Most Australian jurisdictions now have differing practices and procedures which could all be encompassed within the broad notion of restorative justice, and a number of Australian cities have embraced or are preparing to embrace restorative practices, and that's a topic to which I'll return because, of course, Newcastle is one of them. Notwithstanding its relative novelty, restorative justice principles have been embraced by a number of United Nations organisations, and as long ago as 2002, the Economic and Social Council published a statement of basic principles on the use of restorative justice programs in criminal matters. In that statement of principles, member states were encouraged to consider the formulation of national strategies and policies aimed at the development of restorative justice and at the promotion of a culture favourable to the use of restorative justice among law enforcement, judicial and social authorities, as well as local communities. A few years later, in 2006, the UN Office on Drugs and Crime published an extensive handbook on restorative justice programs. Key concepts are defined in that handbook, which describes the features of restorative justice programs to include a flexible response to the circumstances of the crime, the offender and the victim, one that allows each case to be considered individually, a response to crime that respects the dignity and equality of each person, builds understanding and promotes social harmony through the healing of victims, offenders and communities. It's a viable alternative in many cases to the formal criminal justice system and its stigmatising effects on offenders. It's an approach that can be used in conjunction with traditional criminal justice processes and sanctions, and it's an approach that incorporates problem solving and addresses the underlying causes of conflict, which is an overlap, of course, with therapeutic jurisprudence. It's also an approach that addresses the harms and needs of victims and which encourages an offender to gain insight into the causes and effects of his or her behaviour and to take responsibility in a meaningful way. It's also regarded as a flexible and variable approach which can be adapted to the circumstances, to legal tradition, principles and underlying philosophies of established national criminal justice systems. It's suitable for dealing with many different kinds of offences and offenders, including many serious offences. It's particularly suitable to situations where juvenile offenders are involved, in which an important object of the intervention is to teach the offender some new values and skills. And it's a response that recognises the role of the community as a prime site for preventing and responding to crime and social disorder. And in that UN handbook, which is a very useful source, these concepts are developed at length in the context of examples of restorative justice programs in different jurisdictions, including victim offender mediation programs, of which there are examples in Australia, community and family group conferencing, which there are also examples in Australia, circle sentencing in Aboriginal communities, and restorative justice programs for juvenile offenders, all of which exist in some form or another in different parts of Australia. I'd like now to touch upon some more controversial issues related with restorative justice. The first of those is the notion of shaming. A central feature of restorative justice programs is the opportunity which they provide for engagement between victim and offender. In that context, one of the controversial aspects of that engagement has been the extent to which shaming of the offender through this process of engagement is conducive to positive outcomes, or perhaps negative to them. Shaming in a conference environment may create barriers to successful conflict resolution, although ADRAC contend that the understanding and recognition of the emotional benefits of restorative justice conferencing, including shaming, is increasing. The process, which is known as reintegrative shaming, may assist the offender to understand the effects of his or her crime while maintaining a focus on shaming the action, but not the person. ADRAC suggests that it's necessary to distinguish between shame on the one hand and the promotion of empathy on the part of the offender on the other. Braithwaite has pointed to the positive benefits of shame in the particular context of family conferences involving users of illicit drugs. As he observes, and I quote, "Of course, the other reason families don't want to openly discuss the substance abuse of one of their members, even for legal drugs, is that it brings shame on the family. Here we need to educate the community that acknowledging shame is healthy and helps us discharge shame. Shame acknowledgement also tends to elicit forgiveness and needed help from others. This forgiveness also helps to discharge shame, to put it behind us." In the same paper, Braithwaite describes the advantages of the application of restorative justice processes to other offences deriving from substance abuse, such as drink driving and burglary committed to fund a drug habit. Restorative justice processes applied to offences of this kind have the advantage of providing more time for drawing out the circumstances which have resulted in the offence, as contrasted to what Braithwaite calls production line processing of courts in mainstream lower courts, by which he means that the whole process may be played out in just a few minutes using legal terminology. Restorative justice offers the prospect of shaking the substance abuser out of what Braithwaite describes as drift, that is, where the person drifts rather than confronts the substance problem, provides the family members of a juvenile substance abuser with the opportunity to cry out for the help which they need, and requires the juvenile to sit and listen to the concerns and suffering of their family. Another area of controversy concerns the use of restorative justice processes in cases involving sexual assault in pilot programs in Victoria and in New Zealand. In Victoria, the South East Centre Against Sexual Assault is using restorative justice processes to address the needs of survivors of sexual assault, bringing perpetrators and survivors together in the presence of a mediator. An analogous program in New Zealand, conducted under the name Project Restore, also has attracted public attention because of the significant view that sexual assault is not an offence appropriate for restorative justice practices. That view reflects understandable concerns about a power imbalance between perpetrator and survivor and the prospect of the process re-victimising survivors. Each of these projects is still at a relatively early stage, and I suspect that it remains to be seen whether the concerns which have been identified can be successfully addressed in such a way as to provide benefits for both victims and perpetrators. Another area of controversy concerns the evaluation of restorative justice practices, and in particular the measured outcomes of such practices. Some researchers, notably Smith and Weatherburn, have suggested that studies which show restorative practices reduce rates of reoffending have been methodologically flawed, and that proper analysis shows no effect on either the time until a further offence occurs or the frequency of reoffending. However, as ADRAC points out, other studies have arrived at different conclusions. For example, a study of restorative justice programs in the ACT found lower rates of reoffending amongst violent offenders who participated in conferencing as compared with similar offenders who didn't participate in conferencing. On the other hand, conferencing had no impact on reoffending amongst property offenders and shoplifters. The competing studies in this area were recently analysed by Braithwaite. He observed that various studies conducted by Strang, using random assignment to restorative justice practices, found a statistically significant effect across combined studies in terms of reducing reoffending. As Braithwaite observes, some studies, mainly those involving property crimes, showed disappointingly inconsequential effects of restorative justice practices, whereas others, mainly those dealing with violent crimes, show surprisingly large effects. As he points out, the challenge for the future lies in endeavouring to identify the reasons why differing practices seem to show quite different outcomes. But one outcome is consistently reported by all studies, and it's an important outcome, and that relates to the response of victims. Studies consistently show that victims who participate in conferencing are very satisfied with the process. Those levels of satisfaction may well reflect a positive response to high levels of victim dissatisfaction with conventional criminal justice system processes, the feeling of disengagement and disempowerment that I mentioned earlier. In my view, there's much to be said for the proposition that a significant improvement in victim satisfaction is, in itself, quite sufficient justification for undertaking restorative justice processes, irrespective of the controversial effect of such processes upon the rate and time of reoffending. The last topic I wish to address is, which is what I usually say when I'm about a third of the way through my paper, is the emerging topic of restorative justice cities. It's no coincidence that this paper is being delivered on the eve of a conference which will specifically address the steps which can be taken to render Newcastle a restorative city, and I hope to provide some context for that conference by this paper and by my following reference to a number of other restorative cities. Canberra is one of them, but I'll skip over that a little because Professor Braithwaite will be addressing the conference. He'll say much more about it more recently, but it's sufficient for present purposes to observe that the current Attorney-General of the ACT, Gordon Ramsay, is extremely supportive of restorative justice principles. He's spoken eloquently and enthusiastically about them publicly, and he's asked the Law Reform Advisory Council of the ACT to identify areas in which restorative practices could make the greatest impact on the lives of the most marginalised people within the ACT community. That committee came up with child protection and public housing as the two areas in which restorative practices could make the greatest impact, and the Council has published an issues paper seeking responses to a number of issues which it's identified in those two areas. Another city which is prominent in this area is Hull, and the Hull Centre for Restorative Practice was established as a result of work undertaken at a primary school in the Hull area, which adopted restorative practices within the school, resulting in what's been described as a transformation. Following that success, restorative practices were developed in many other areas, including policing and in the resolution of neighbourhood disputes. And the expansion of restorative practices in other areas of endeavour is facilitated by the Centre. On its website, the Centre observes that, and I quote, "It's important to emphasise that restorative practice is a way to be rather than something to do." They go on, correctly implemented, a restorative community will spend far more of its time on proactive community and relationship building activities than it does on reactive corrective activities. The Centre asserts very positive outcomes following the introduction of restorative practices in a variety of fields. Benefits are said to include savings of £3.5 million by reducing entrance to the youth justice system, cutting custodial sentencing by 23%, reducing reoffending to 13%, as compared to a national average of 20%, and a significant reduction in antisocial behaviour orders. In the area of education, the introduction of restorative practices is said to have resulted in an 80% reduction in the exclusion of students from schools and to a 65% reduction in staff absences in one secondary school. Similar advantages are said to have been derived in areas of social care and in fostering and in adoption. Leeds is another city which has adopted restorative practices, but again I'm running out of time, so I'll skip over that. Wanganui, New Zealand, is working towards becoming a restorative city, utilising victim offender conferences supported by the Wanganui Restorative Practices Trust, mainly in the juvenile justice area. Oakland, California has embraced its description as a restorative justice city in a variety of areas and perhaps broader than other cities, including, for example, making the city a place where healthy, affordable food is hard to find at the moment, changing that into a city in which residents eat healthy home dinners, shifting from shouting to listening, shifting the relationship between police and civilians from mistrust to positive contact. Now, of course, I've saved the best for last. The symposium that will be held over the next 2 days is intended to kickstart an initiative to transform Newcastle into a restorative city by building social cohesion and healthier communities. The symposium will draw upon steps which are being undertaken by various agencies in the Newcastle area. They include a police program in the Hamilton South housing estate, which is not far from here, and which focuses on restoring harmony by acknowledging those with good behaviour, by utilising a multi-agency approach, by removing non-tenants, using police to remove non-tenants, by the council proactively cleaning up the estate, and by a proactive rather than a reactive approach to dealing with people with mental health issues. Following the introduction of these measures, the crime rate in the housing estate area reduced by 15%. The Victims of Crime Assistance League in New South Wales will also provide support for victims in the Newcastle area. Life Without Barriers Newcastle will aim to assist families to find a solution using family group conferencing and other associated processes with a view to reducing the high rates of children in care in the Newcastle area. And the Drug Court of New South Wales, which is perhaps more of an example of a solution-focused court than a traditional restorative justice practice in strict terminology, but that drug court also operates in the Newcastle area. Now, in conclusion, because I am really now coming to the end, it's the augmentation of restorative justice's processes with restorative practices, both within and outside the justice system, that can transform a city into what will be recognised as a restorative city. The Newcastle as a Restorative City Symposium that's going to take place over the next 2 days has attracted eminent speakers from all over the world. I've no doubt that their accumulation of their expertise will provide Newcastle with the impetus and the information required to implement the objective of transforming Newcastle into a restorative city. And I hope I've been able to provide a bit of a curtain raiser for that event by making my own modest contribution to that important objective. Thank you very much for your attention.
Sure. Yeah, sure.
Well, what a wonderful speech. And we're so fortunate to have the Chief Justice of Western Australia come and visit us and to actually give us a fabulous way of thinking about how we can become a restorative city. Of course, for the next 2 days, we'll be working on Newcastle as a restorative city and bringing together members of our advisory group and experts to think about this not just in terms of restorative justice, but how so many different strands can be brought together to create a socially innovative and vibrant city. So really exciting to be working on that, I think, into the future. And I do acknowledge many of the people here tonight who have been part of that work in bringing together the symposium and actually thinking about what this might look like for the next 5 years. Excuse my voice, I've been travelling a bit and it's not as good as it sometimes is. I do want to thank Chief Justice Wayne Martin and also bring him up to the front to ask some questions, to answer some questions of the audience. So if anybody has a question within the audience, any hands up?
Or comment or criticism?
There's one just here, yes. If you can stand up and say who you are and how you come to be here, that might be useful too.
Hi, my name's Conrad and I'm from the Law Association at Newcastle University. I just wanted to ask, with regard to, obviously it is a very, having a restorative system is very virtuous and it does altogether reduce crime. How do you think is the best method to ensure that recidivist offenders don't actually take advantage of that system to ensure that potentially, because there's no doubt that whilst harsher punishments do have an effect on increasing crime by associating people with other criminals, obviously it does still capture those natural recidivist offenders. So how would this system kind of obviate that kind of...
Thanks for the question. It's a very real concern. There have been projects, victim offender mediation programs in operation for a long time now. One of the programs you might have heard of is a program called the Sycamore Tree Project, and it involves putting groups of offenders in prison together with groups of victims, usually not the victim of their offence, but victims of other similar types of offences. And the criticism of that program at the time it was developing was the offenders are just doing it to increase the chances of getting parole. So they will be gaming the system, they'll just be going along these meetings, and they'll, as I say, just be doing it solely for the purpose of getting some time out of prison, and they'll just see it as a soft option. Experience has shown that the project actually has a profound effect upon offenders, and it has an equally profound effect upon victims as well. So that offenders might go into the program thinking this is a soft option, but they come out of it very different because the program requires them to engage. If they're going to successfully complete it, which is what they've got to do in order to get parole, or get a benefit from parole, or in the case of the programs we're talking about, in order to have their participation in restorative justice taken into account at the time of sentence, they've got to complete the program. They've got to be assessed as having been genuine and active participants in the process. And if they do genuinely engage, then experience tells us it does have a profound effect upon people. It gives them insight into their own condition, creates empathy for offenders, makes them see the consequences. Often a lot of these offenders have been blind to the consequences of their conduct. They are entirely introspective, entirely self-interested. They're just concerned about the consequences of the offending for them. They don't see the other side of the equation. So for the first time, they get that opportunity, and it does have that benefit. But certainly the risk is there. The only way you can deal with it, I think, is by active facilitation of the project and reporting truthfully upon offender engagement. But thanks for the question. Yeah.
Yes.
Hi, my name is Tony Brown. I'm chairperson of Newcastle Local Drug Action Team. I was very interested in your comments about fetal alcohol spectrum disorder, which is the most common form of non-genetic birth defect and represents itself in three ways: intellectual, developmental impairment, and also physical impairment. I saw a report recently that WA surveyed juvenile offenders or in juvenile justice system. Around about 30% of the kids there had FASD.
35%, Tony.
35%.
Even worse.
Corrected.
Yeah.
But it's caused solely by prenatal alcohol exposure. One of the problems of the developmental impairment is that kids with cognitive impairments can't discriminate between right and wrong, and secondly, don't learn from the mistakes that they make. And that seems to be a fundamental conflict with some of the principles of punishment. How is WA dealing with that massive problem?
Well, not nearly as well as we should, Tony, which is something I've said a number of times in court in a number of tragic cases that have come before us. But to give you some idea of the size of the problem, Telethon Kids, which is a charity which is doing a lot of work in this area, did a survey in the Fitzroy Valley, which is the area around Fitzroy Crossing. If you move inland from Broome, that's the Fitzroy Valley. 1 in 8 kids born in the Fitzroy Valley suffers from FASD at the time of birth. A lot of those kids are predestined to end up in the juvenile justice system because, as you've mentioned, one of the consequences of this lifelong cognitive disability is an inability to appreciate the consequences of one's actions, and a tendency to what's sometimes called short-run hedonism. That is, things that give pleasure in the short term without thinking about the consequences. If you think about it, those characteristics are inherently likely to bring you into contact with the criminal justice system. We've been really bad in Western Australia at identifying kids who are at risk. I'll give you a terrible case that I foamed at the mouth a bit about this. A young Aboriginal man was taken into care of the state at the age of 2 because his mother was an alcoholic. You would have thought that that might have attracted somebody's attention to the possibility that he might be FASD affected. He then had all the classic symptoms of FASD child affected. He dropped out of school about the age of 10, had poor concentration, even slight facial abnormalities, and then, as with a lot of kids, started self-medicating using alcohol and then cannabis regularly at about the age of 13. By 15, he is the father of a young child with a 15-year-old partner. He's left alone the child was born prematurely, so it was kept in hospital for 6 or 8 weeks. The mother left the room, leaving him alone in the room, and he bashed the child's head against the wall and killed it at the age of 15. He's on a charge of murder. represented by a very senior criminal lawyer in Western Australia, seen by a very senior experienced forensic psychiatrist, a senior forensic psychologist, goes in front of the president of our children's court, who's a very experienced judge. None of them thought to ask about FASD. He was also, because the case was so terrible, it was the subject of an upper house inquiry by the upper house of our parliament into, this kid was in the care of the state. He had been pretty well all his life. So there was an inquiry into that. Neither the upper house committee, nor the judge, nor the lawyers, nor the psychiatrist, nor the psychologist ever thought to ask about FASD. So the kid was sentenced on the basis that he was just a rotten kid. He then went into Banksia Hill, which is our juvenile detention centre, and got caught up in the survey that you mentioned, Tony. And so by coincidence, he got swept up into that survey and was found to have FASD. Well, surprise, surprise. You know, the conduct was so bizarre, FASD was screaming off the page at you. He then appealed, came to us. We reduced the sentence significantly because, of course, the mitigatory, the culpability of his conduct is reduced significantly by the fact that it was influenced largely by a condition that he suffers through no fault of his own. What that case continues to show us is that we are extremely poor at recognising FASD even when it jumps off the page at us. We're poor at recognising it, we're poor at diagnosing it, and we're poor at responding to it. Now, of course, you can't treat FASD, it's a lifelong neurological deficit, but you can reduce risk, and the Canadians are much further advanced than us in this area. You can have behavioural training programs, you can put people effectively in sheltered environments in which their risk can be reduced. Because of the size of the problem in Western Australia in particular, we need to do those sort of things. We're not at the moment, but I'm hoping sort of things. I talk about FASD every opportunity I get, and I've said it in a number of cases. There have been 3 or 4 landmark cases in the Court of Appeal we've drawn attention to it. I'm hoping we're attracting the attention of government, but it's got to get government, it's got to get resources. A lot of the worst parts of the state where this occurs are very remote, so getting diagnostic facilities to remote parts of the north of our state, getting resources there to deal with kids who suffer from these problems is very difficult and very expensive, but we've just got to do it. So thank you very much for the question. As you can see, you've touched a nerve.
We've got time. Yes.
You mentioned earlier about how legislators are sort of reactive to community resentment, that community resentment's being stoked by popular media.
Yep.
Do you think that there should be more of an onus on the legal community to make a grassroots effort to correct misconceptions and sort of like, so like the typical one is like, oh, they just get off on a mental health thing.
Yeah.
Do you think there should be more of an onus on us as legally educated?
I think we certainly should. I think we ought to be saying much more about things. For example, there is a popular perception out there that crime is rising and punishment is decreasing. So that crime is going up, we're drowning under a tsunami wave of increased crime, we're not safe in our beds, we're all at risk of terrible violent crime. And in the meantime, judges and magistrates are reacting pathetically and insipidly, giving offenders a cuddle, sending them on their way with a soft toy, nobody ever goes to prison. And of course, neither of these things are true. In fact, the exact opposite is true. Generally speaking, crime in most Western democracies, including Australia, is going down consistently. On the other hand, levels of punishment are growing up dramatically. Our prison population, as I mentioned earlier, is growing at a much faster rate, while crime rates are going down. So why the disconnect? There's a public misconception there. The media must bear some responsibility, but I don't subscribe to the view that there's, well, with some exceptions, the Sun Herald in Melbourne is running an orchestrated campaign of disingenuous falsehood. Don't quote me on that. But mostly it's because of the nature of news. So that if, for example, if the Sydney Harbour Bridge stays up, you don't see on the front page of the Sydney Morning Herald, Sydney Harbour Bridge stays up again last night. But if it falls down, that's going to be pretty newsworthy. So in the same way, you're not likely to turn to page 3 of the West Australian newspaper, even if you are misguided enough to open that worthy journal. You're not likely to turn to page 3 of the West Australian newspaper and read an article saying that Chief Justice Martin took into account all relevant facts and circumstances and handed down a sentence that was regarded as eminently reasonable by all involved in the case. It's just not newsworthy. Nobody's interested in reading it. But if there's an outraged secondary victim of a homicide who says that the penalty that I imposed for manslaughter doesn't reflect the value of the life of the mother, brother, father, sister, whatever, that's newsworthy. So it's going to get reported. And people will read about that article. And because it's only news of that kind that is newsworthy, that's the only stuff that gets reported. Because they're the only stories that people see, it's mostly sentencing is the stuff that is mostly newsworthy. Even the most avid consumer of news might read 30 or 40 stories about that per year, but they're the only stories they read about the criminal justice system. And so they think that these cases are representative of everything that's happening in the criminal justice system, when in fact, they're self-selected as being newsworthy because of their unusual characteristics. And those 30 or 40 cases are to be compared to the penalties imposed in the hundreds of thousands of cases that are decided by courts around Australia. And the other thing is that the original sentence might be reported on page 3 in scandalous terms. When the appeal is heard and allowed and the sentence increased, if it's reported at all, it's reported in a small column on page 53 because it's just not newsworthy, the fact that it's corrected. So, as I say, with one or two exceptions, I don't think there's a media campaign, but it's just the nature of news results in quite false impressions. And the dangerous thing is that policymakers respond to the impression, public impression, because it's vote-worthy, not to empirical evidence on what's actually happening. That, I think, is a big problem. Thanks for the question.
Yes, so if you could stand up and say where you're from.
John Braithwaite from...
Well, I hope I didn't misrepresent you, Professor.
Thank you for those kind comments. In Larissa Barrett's film After the Apology, she points out how much dramatically worse Indigenous child removal has become since the 2007 apology. She also points out that in New South Wales law there's a principle of restoration, where the principle of restoration has a particular meaning in New South Wales law. I don't know whether it does in Western Australian law, that children who are removed from Indigenous mothers must presumptively be given the opportunity to be placed with a member of their own extended family, and if that's not possible, with an Aboriginal family.
Yeah, that's part of Western Australian law too.
Yeah. But the film also points out that principle is not being applied, and that's why we have this worsening situation rather than improving situations. It's actually a lot worse in my jurisdiction, the Australian Capital Territory, than it is in Western Australia, which would surprise most people. And it's also worse here in Newcastle than it is in Western Australia. I wonder what your reflections would be on the possibilities for more robust judicial enforcement of something like the principle of restoration.
I would love to think that there was something the courts could do in answer to this, because it is a very difficult and very serious problem. So that you're entirely right. The rates of Aboriginal children in out-of-home care have soared over the last 10 years, astronomically. It's depressing. The spectacular rise in the rate of out-of-home care is extremely depressing. And we know that, as I mentioned, involvement in out-of-home care is a very strong criminogenic factor, so that we know that kids who are placed in out-of-home care are very likely to end up in the juvenile criminal justice system and very likely to graduate into the adult criminal justice system. And we're dealing with Aboriginal kids. We've got a massive problem with gross overrepresentation of Aboriginal people in the criminal justice system, so it's just going to exacerbate that problem. So it's a very serious issue that we need to confront. But the problem with the application of the principles to which you refer is that there just aren't enough family members or Aboriginal people who are willing to take the number of kids for whom we need homes. We know from bitter experience, we've had a Royal Commission telling us that institutional care is an absolute last resort. Institutional care is potentially disastrous. If we could find more culturally appropriate homes for these quite troubled kids, then that would obviously be the solution. But the difficulty is that a court can't order a home to exist. If they don't exist, you've got to find them. What I think we need to do is to be more proactive about finding appropriate homes. You exhaust the family, and families, the Aboriginal families are very good, by and large. If there is a good family member, they will take responsibility because it's part of Aboriginal culture. They have a much broader notion of family than European people do. But if you don't have a family member, it's hard to find enough other appropriate homes. I think the problem, we've just got to meet it with money. I think we've just got to get used to the notion that we need to pay proper commercial rates to Aboriginal people to take these kids on. It's an investment that would pay enormous dividends, I think, in terms of preventing harm down the track. To give you some examples, to put a kid in Banksia Hill in Western Australia for a year costs $365,000. It's a nice serendipity. It's $1,000 a day to put a kid in juvenile detention in Western Australia, and 80% of those kids are Aboriginal. You can buy a hell of a lot of home care for $365,000 over a number of years. That $365,000, we could send those kids to Geelong Grammar and to a Swiss finishing school and have change. But instead we're sending them to Banksia Hill, and the only thing we know confidently is that those kids are likely to graduate in the criminal justice system. So instead of spending truckloads of money on punishment and detention centres, we ought to be spending, in my view, a lot more money on proactive prevention through paying people proper wages to bring Aboriginal kids up in the way in which they're entitled to be brought up like every other Australian. So it's a difficult problem, but I think we've just got to get more inventive, more proactive. We've got to get more serious about it, because it's a problem that will undoubtedly have very dramatic and adverse repercussions down the track. So thanks for the question.
We have time for one last. So, ma'am, if you could stand up and say your name.
My name's Wendy Pease and I'm a Newcastle local. I think the fact that there's been a 15% reduction in crime in Hamilton South is one of those good news stories that didn't get into the Newcastle Herald. And I'm wondering if you can say a bit more about that, over what period of time have we been first?
Now you've caught me out because I'm from Western Australia. But is there anybody here in the audience who can answer that?
There are quite a few. We actually have a video on our website about that project, and we can certainly put you in touch with people if you want to know more information. We actually have a video of the police talking about it and the length of time. If you're interested in seeing it, please do contact us.
Can I ask one question?
Yes, Judge.
Roy Ellis, I'm District Court Judge here. Chief Justice, what do you think the chances are of change being brought about within the legal system as distinct from the political system? At the moment, as judges, we have to operate on this fallacy that deterrence is a principle that works. We all know it doesn't, but we can't say it. In fact, we have to say the opposite. So is it going to be entirely dependent upon political will to change it, or is there some way it can be changed within our system?
Look, I think most sentencing laws, I only know the Western Australian sentencing law well, most sentencing laws are pretty flexible, so that you can adapt most laws. And a lot of, for example, our drug court doesn't have any legislative backing, nor does our mental health court. We operate it through the flexibility that exists within our Sentencing Act. And you can do things like, you can encourage conferencing through deferring sentence, so that we have a mechanism, I assume you do in New South Wales, where you can postpone sentence for 12 months. Yeah. So you can require people to participate in processes. So you can use techniques like that. What you do need, though, is the support of the Court of Appeal. And that's the problem. That's where I think there is the capacity for lawyers for judges and courts to make change, but it needs to be at all levels of the system. So that if you get people at first instance doing innovative things, they need to be supported at appellate level, which is one of the problems, I think, because if you get appellate lawyers who haven't themselves had that experience down at the grassroots level and seen how these things can work, then you get a more traditional and more reactive and less sensitive and nuanced approach. So that, I think, is where the potential problem lies. But I'd encourage judges to be more innovative and they're, give it a go, and if you get wrapped on the knuckles by the Court of Appeal, that's what, so what? That's what they're there for. It doesn't mean that, just because they have a different view doesn't mean they're right. Yeah.
Okay, I think we're moving towards revolution, and I do know that the Court of Appeal is sitting in Newcastle very soon. If you could join with me for this one, thank you so much.